Most people think they'll deal with their will later. Later, when they stop working. Later, when the kids are older. Later, when life slows down. But here's the problem. Later often becomes never. And by the time you hit retirement, the clock is already ticking on the two things that matter the most: capacity and control. If you wait too long to review your will, you may not be able to change it. Or worse, you may leave behind a document that's completely out of step with your finances, your family, and your final wishes. That's not just a legal issue, it's a risk to your legacy. That's why age 65 isn't the time to start planning, it's the time to finish. So if you're in your 50s or early 60s and your will hasn't been touched in a decade or more, now is the time to act before complexity sets in and your options start to shrink. Hi, I'm Danny Perro, Senior Investment Advisor at CG Wealth Management. I work with Canadians who are entering a new chapter of retirement, downsizing, succession planning, and wanting to make sure that everything is structured properly, including their estate. If you've been watching this channel for the last month or so, I want to thank you for liking, subscribing, and commenting. One of the biggest gaps I see is a will that hasn't been updated in 10, 15, or even 20 years. On the surface, everything seems fine. But once we dig in, we find outdated executors, missing assets, and costly blind spots that could cause major problems down the road. In this video, I'm going to show you exactly why updating your will before age 65 is one of the smartest estate decisions you can make, and what to consider as you prepare for the next phase of life. If you find this video helpful, don't forget to like, comment, and subscribe for more expert financial content. Number 1, your financial life changes more than you think after 60. When you're in your 30s and 40s, your will is usually simple: guardianship for your kids, basic asset distribution, maybe a few named beneficiaries. But by your late 50s and early 60s, everything shifts. You may have corporate shares, rental properties, registered and non-registered investment accounts, a holding company or a trust, or a spouse with different retirement assets and timelines. These aren't one-size-fits-all assets. They have different tax treatments, ownership rules, and implications for your estate. Your will hasn't been updated to reflect the complexity, and you could be leaving a tax mess, probate delays, or even family conflict behind. Number 2, you need to align your will with your retirement plan. Here's a common problem I see with my clients. Someone retires at age 62, sets up income streams from their RIF, pension, and TFSA, but their will still reflects a life when they were earning T4 income and had young dependents. There's a mismatch there, and it causes confusion when the time comes to settle the estate. Worse, it may not reflect how the assets actually should flow across accounts and family members in retirement. For example, are RIF and LIF beneficiaries aligned with your intentions? Is your will structured to offset potential OAS clawbacks or tax burdens on your spouse? Do you know how joint accounts and named beneficiaries interact with your will? If these things aren't coordinated, your estate plan might look solid on paper, but fall apart in practice. Number 3, cognitive decline becomes a real consideration after 65. This one's uncomfortable, but important. By age 65, the risk of cognitive decline begins to increase. By 75 or 80, that risk is significantly higher. And if you lose capacity without updating your will, you may not be able to legally change it again. And that means an outdated executor stays in charge. An old distribution plan goes into effect. A court may need to get involved if family members contest the will. Updating your will while you're mentally sharp and fully informed isn't just a legal decision, it's a gift to your future self and to your family. Number 4, executor and power of attorney rules often need updating. When was the last time you looked at your executor or who your executor is? Many people name a sibling, a parent, or a close friend decades ago. But as time goes on, that person may no longer be alive, they may not be capable of managing a complex estate, or they may live out of province, making probate difficult. The same goes for your power of attorney, for both property and personal care. If your POA is outdated or doesn't reflect your current relationships, you could be giving decision-making power to someone you no longer trust or even communicate with. Updating these roles before 65 ensures that people you've appointed are actually willing, capable, and legally positioned to act on your behalf. Number 5, you may need to reflect business or real estate holdings. Many Canadians nearing retirement have built wealth in more than just investment accounts. You might own a private corporation, a rental portfolio, a vacation property, or an asset inside a family trust. These require specific planning in your will. Who inherits control of the business? Will real estate be divided, sold, or retained? Should one child receive more because another is already involved in the company? If these questions aren't answered clearly, the CRA and potentially a probate judge might end up deciding for you. That's why business owners and real estate investors must update their wills well before retirement. Number 6, the earlier you update, the more you can strategically plan. Most people think of updating their will as a simple housekeeping task. Change a name, swap a beneficiary, update a few account details. But the truth is, early updates open the door to far more powerful strategies, especially for Canadians who have built real wealth heading into retirement. If you're still healthy and in full control of your finances before age 65, you have a unique window of opportunity to do the following. Number 1, set up dual wills to reduce probate fees. If you own private company shares, art, or other assets that don't require probate, a dual will structure can separate those from your general estate. This simple legal move could save your estate tens of thousands of dollars, but it needs to be structured before death. Number 2, use testamentary trusts to protect beneficiaries. Worried about a child going through a divorce or an heir with poor financial habits? You can build flexibility and control into your will using a testamentary trust, so your estate supports your loved ones without putting them at risk. Number 3, plan charitable giving to reduce your estate's tax burden. If giving back is part of your legacy, strategic gifting through your will or estate can reduce your final tax bill and leave more in the hands of both your family and the things you care about and the charities that you care about. Number 4, coordinate with your business exit or corporate freeze. If you're a business owner, updating your will before you exit or restructure can help ensure corporate shares, dividend rights, or family trusts are handled properly. This isn't just about estate clarity, it's about minimizing tax when control or ownership changes. Number 5, manage RRSPs and RIFs and insurance payouts across generations. Designating beneficiaries directly on registered accounts or life insurance can avoid probate, but if done without coordination, it can conflict with your will or create unfair distributions. Updating your will early lets you review and align every piece of your estate. And most importantly, early updates buy you peace of mind. Because once you hit your 70s or 80s, your options narrow. Health risks increase, complexity grows, and the window to implement strategies like trusts, reorganizations, or charitable structures can quietly close. Updating your will before 65 isn't just about getting it done. It's about giving yourself the time, clarity, and control to do it right. Here's the bottom line. Your will is not a one-time document. It's a living part of your retirement and estate strategy. And if you're heading into your 60s without reviewing it, you're not just overdue. You may be underprotected. A will that's out of date doesn't reflect your current assets, your real priorities, or your family's actual needs. It can create delays in probate, confusion among beneficiaries, and extra taxes you never intended to pay. And in many cases, those mistakes are completely avoidable if you plan ahead. So don't wait until you're already retired. Don't wait until your health changes. And don't wait until the complexity becomes unmanageable. If you want a second opinion on your estate plan or help coordinating your will with your retirement strategy, book a time with me using the link in the description below. We'll walk you through your full picture, your assets, your goals, and the best way to structure your will so your wealth is protected and your wishes are clear. Because when it comes to your legacy, clarity is the greatest gift you can leave behind. Thank you for watching, thank you for listening, and remember, money never sleeps.